So now that we're on the topic of IP, and since you're a specialist in IP law, I wanted to ask you about Order 39, interim
Yes.
injunctions, and its importance
Yes.
To intellectual property practice.
Well, I'll say very safely it's the most important order there is
Okay.
for an IP litigation. The entire purpose of IP litigation is to get injunctions. You want an interim injunction. You want an injunction to be on from the day you file the suit if you are the plaintiff.
Right.
So therefore, typically what you do is with the suit and the documents that go with it, you will also file an application under Order 39 Rule 1 and 2. You will press for hearing.
Yeah.
You would be very happy if it's ex parte. That just makes your order easier
How
to get.
common is it to get ex parte injunctions in IP?
If it's a small defendant, it's very common.
Okay.
If it's someone who's filed a caveat, obviously he'll be there.
Okay.
You know,
And
waiting
what's a
for you.
caveat in this
A
context?
caveat is basically a document that you file in the court when you're anticipating a litigation.
Okay.
So, for instance, you're making a drug that you believe somebody thinks is infringing.
Yeah.
You would go file a caveat.
It's anticipatory.
So, correct.
Yeah.
So, that means that the plaintiff can then not move court without serving you an advance copy.
Okay.
And that happens, you get to know the evening prior, you go to court in the morning, and then you say what you have to say.
And what about this whole American cyanamide rules? Is that just something we learn in theory, or it's very important in practice?
It's something we follow every day.
Okay.
You will put in those words. You will say prima facie case. You will say balance of convenience, and you will explain that.
So you'd go beyond just sort of alluding to the principles.
Yes.
You would apply it to the facts.
You would apply it to the facts. Yes.
Yeah. And what's the nature, like, what's the time limits? Like for an injunction, if a client comes to you, are IP actions sort of, is time is of the essence?
It always is.
Okay.
Always of the essence. Because you want to stop the infringement as quickly as you can.
So someone who's going into IP practice should be prepared for long hours.
Of course.